Special meeting of the Zoning Board of Appeals. And so, now that all the members are present,
Can't hear you, sir.
see if that works any better? Yes, no? Okay, well, so this is a special meeting of the Zoning Board of Appeals. All the members are present. It is 8 August. It is 7:11. Wow, good numbers. So we will open the meeting. The board members present: Celia Waters, Sean Flynn, myself, Hank Nussbaum, Cindy Givens, and Robert Wisnia. It is my understanding that the whole point of this meeting was, listen to nice music. The point of the meeting is to decide whether, in fact, the zoning enforcement officer made the correct decision on applying the ordinance. So we have asked, in order to be able to make that decision, we asked the town council to help us understand the law and how it should be applied. And so that's really the whole point of today's meeting.
So we, like we said, we were going to consult with town council. We did get an opinion from him. I'm going to outline the opinion we received, and I do want to preface by saying that the board members are not constricted by this opinion. They can take this opinion however they like and make their own opinions and the interpretations of those regulations. So town council first specifically references, hold on. Sorry, of course my computer locks. 1.6 of the regulations are interpretations and intent of regulations, which is meant to apply generally to all of the town regulations. And he points to section A and section B. Section A, which says any principal use of land, building, or structure not expressly permitted by these regulations in the various districts is prohibited. And B, any use not expressly permitted in the regulations is prohibited. So the first argument is that because this sign is not expressly permitted in the regulations, it is therefore prohibited. He next points to the actual sign regulations, which are section 4.5 of the regulations, signage, and quotes the applicability section, which states no sign, billboard, signpost, or structure designed to advertise the sale, rental, construction, or improvement of said building or premise, or both, or designed to advertise the business conduct upon the premise in the business industrial district, in the general business or development district, or designed to sell products permitted by these regulations to be produced on the premise in a resident district which is visible and legible from a public street shall be erected, attached to, or maintained on property subject to these regulations, except as permitted by the provisions of these regulations. He goes on to say these regulations do not specifically permit this type of sign, and specifically points to two sections. The first section is section F, signs permitted in residential zones. He argues that section 1 applies, which says the signs in table 4.5 are permitted for residential use in a residential district, provided that such signs comply with other provisions of section 4.5. So table 5 only allows for two types of signs: a sign bearing the name and or street address and or permitted residence office of the residence, or a garage or tag sale sign advertising a sale to be held within 3 days following the erection of such sign of personal property and effects which are owned by the owner or tenant of the premise and used for residential or domestic household purposes. Such sign shall be removed upon completion of the advertised event, no permit required. He says that, again, because the Chris sign does not fall within those two types of signage, it's therefore not permitted. He then points to section E, signs permitted in any zone, which says the signs in table 4.4 are permitted in any district without a zoning permit, provided that any such sign shall comply with the other provisions of this section. If you turn to table 4.4, there's 10 types of signs enumerated in this table. I'm not going to read them all into the record, but he argues that none of these 10 enumerated provisions apply to the sign or permit the sign to be located on the residential property. So in short, he maintains that the sign is not permitted by the regulations and therefore should be denied. And if the board would let me, I'd like to state my piece and my explanation of the regulations. Or do,
I'm okay with that. Are you guys okay with that?
Sure, that's okay, but as you said, right, go ahead.
as I said, what?
Well, that you're entitled to make your own opinion, any board member is entitled to make their own opinion.
Correct.
Based on the town attorney. I'm not sure what additional we have an interpretation. Does any board member want to hear another interpretation, I guess is the real question.
I think I'm allowed to say my piece.
I'm interested in hearing it.
Okay, then let's do it.
I was specifically told by town council I do not have to follow this interpretation.
Okay.
So I'm going to read a section from Guidelines for Applicants to the Zoning Board of Appeals, published in James A. Kuhn Local Government Technical Series. Specifically, the section that says, what is the basis for the ZBA's decision on an interpretation? If requesting a reversal on interpretation basis, the applicant must prove that the enforcement officer's decision was incorrect according to a proper reading of the municipality's zoning regulations. If the ZBA has heard a case in the past which involved an interpretation of the same provisions, the ZBA's decision will be consistent with its prior ruling. As we said last time, we did not have any application in front of us that raised these issues. This is the first time. If the ZBA has never interpreted the particular provision at issue, it will use its best judgment as to the municipal governing board's original intent in enacting the provision. Secondarily, the ZBA will try to arrive at the best practical solution for future application by the enforcement officer. Careful and thorough reference will be given to all definitions and other provisions of the regulation. If necessary, the ZBA will refer to authoritative publications on planning and zoning law. The applicant may, of course, use those same resources in presenting his own case as well. I'm going to start by, and I read this because specifically for, I think there's multiple interpretations of this regulation, and particularly we need to look to original intent of the enactment of these provisions. I'm going to go through how I read these regulations specifically and then look to the intent afterwards. As I mentioned, as I read into the record, the application section which is section B, meaning what these regulations apply to. The section only lists 3 potential categories for signage that are subject to these regulations. 1, a sign, billboard, signpost, or structure designed to advertise the sale, rental, construction, or improvement of said building or premise. 2, signs designated to advertise the business conducted upon the premise in the business industrial district, in the general business or development district. And 3, signs designated to sell products permitted by these regulations to be produced on premise in a residence district. To me, this means that we only have the authority to regulate these types of signs, and these regulations do not apply to any other types of signs. If this section was intended to limit only these types of signs in town, it could have specifically said this in its language. Therefore, I do not believe that these regulations apply to the Chris's Farm sign. Next, I'd like to point to Section C, which states prohibited signs. There are only 2 categories. Section C1, which only applies to signs prohibited for use by businesses, and C2, which applies to signs existing at the time of the adoption of these sign regulations, which become non-conforming. This section is very specific and does not specifically prohibit the types of signs that Chris's Farm has put up. To me, the use of this section in these regulations could have been more specific and has failed to do so. It could have listed what is otherwise prohibited by these regulations and does not. If this section is viewed as non-inclusive, that there are other prohibited signs, this section to me is superfluous, meaning it's not relevant. Assuming these regulations apply to the Chris's sign, I believe there are some issues with the language. The phrase non-residential use in the regulation is ambiguous. There are 2 ways to interpret what these regulations are referring to when they use the phrase signs permitted for non-residential use. First interpretation is the sign is advertising for a non-residential business such as the Chris Farms ice cream shop. The next interpretation is the sign is advertising that the property itself is a non-residential use, such as a winery or a farm. Nevertheless, it would seem to me that only sections E and F apply, as counsel suggested. However, section E merely states what signs do not require a permit as listed in 4.4. It does not, as town council suggests, limit town signs to only these 10 categories. There is no limitation language. Presumably, one could argue that other signs are permitted in town, but they merely require a permit from town. Next is section F, and this is where town council and I disagree as to what section applies, based upon the language of non-residential use. I believe this non-residential use can be interpreted meaning the sign is advertising for a non-residential business, such as the Chris's Farm ice cream. Therefore, section 2, which states the signs in table 4.6 are permitted for non-residential use in any residential district, such as religious institutions, libraries, museums, art centers, historical societies, schools, municipal uses, and nonprofit agencies, provided that such sign shall comply with other provisions of section 4.5. Here, it would seem to me that the Chris sign falls within category 3 in table 4.6, in which case a special exception would be required. A special exception would require an application be submitted to town planning and zoning. Now, I'd like to talk about the drafting intent of these regulations and why I think it supports my argument. I asked Chris, who has worked very diligently to get us the information we needed on this and was significantly helpful in getting me the information I needed. She provided us with a version of the regulations that were in effect up until 2010, and then the regulations that went into effect in 2010. In addition to that, we were provided with meeting minutes from meetings that discussed these regulations, minutes from June 7th, September 7th, and November 1st, all in 2010, leading up to the amendment of these regulations in November 2010. There are a few things I'd like to point out that I think are significant in the changing of the language. The initial language did not specify applicability. Like I said earlier, I believe the title of the applicability section means the regulations can only be applicable to 3 categories of signs. The prior regulations did not have that title. It merely said, no sign or other structures designated to advertise shall be erected or placed upon any premise or attached or affixed or painted upon or made part of any building in any district except for the purpose of advertising the sale, rental, construction, or improvement of said building or premise, or both, or of advertising the business conducted upon the premise in the business industrial district in the general business or development districts, or the sale of products permitted by these regulations to be produced and sold on the premise in a resident district. I'd like to point out that that language, furthermore, does not have the language at the end of the regulation, which specifically says, except as permitted by the provisions of this section, which I believe is conditional language attached to these 3 categories, meaning the regulations are only permitted to regulate these 3 types of signs, conditional upon, except as permitted by the provisions of this section. So that language was added, and the title applicability was added, meaning what these regulations apply to. Furthermore, I looked at the proposed language, which was proposed to amend the applicability section, which I believe is significant because it reads, no sign, billboard, signpost, or structure displaying advertising or other matter which is visible and legible from a public street shall be erected, attached to, or maintained on property subject to these regulations except as permitted by the provisions of this section. There are no 3 categories listed. This language is significantly broad. It could have adopted this language and regulated the Chris's sign. It did not do that. When looking at the meeting minutes to determine the drafter's intent, there's no discussion of this type of sign. There is, however, certain comments made by certain members of the committee, particularly on June 7th, 2010, in the meeting discussing the signage. Chairman Kaufman noted, the commission is attempting to promote sign regulation that people want, to encourage compliance and ease enforcement burdens. On September 7th, 2010, another meeting was held to discuss the signage. The commission members discussed the concerns and comments that had been expressed in the public hearing on the proposed sign regulations. In general discussions, commission members noted Signage needs to be regulated in a manner that would meet the needs of local businesses while improving and maintaining the character of the town. Furthermore, in looking at the intent of these regulations, one could merely look to Section A, Purpose, which specifically says this section is intended to promote the public safety and welfare by providing standards to control the local area, number, illumination, and overall design of signs in order to prevent undue distraction to motorists and pedestrians, to ensure compatibility of signs with permitted land use, to provide reasonable standards by which use within the various districts may relate their function to the public, and to aid in preserving and enhancing the aesthetic and historical value of the community. I believe it's the intent that these regulations were not drafted to regulate the Chris's sign. I think that the aesthetic nature of the sign is signature and character to our town. We are a small community, a farming community that wants to promote small and local business. I believe that one driving through the town of Woodbridge would be happy to see a farm sign suggesting there's ice cream down the street. That's the nature of a small town feel. That's my position.
Anyone else on the board?
Well, I really made a very effective review of all that, and I'm impressed, but I do feel.
Excuse me, I'm sorry, I can't hear you.
Okay. You did make a very detailed analysis, which I appreciate, but I do feel the town basically does have a right to regulate signs. However, I agree with you that, Woodbridge, Orange, Bethany, we're all close-knit communities. We support agriculture, and I even remember years ago when the Massaro farm was run by the Massaros, that Russell Carrington, I still the picture, he came down with his large tractor and the harvesting material to help the Massaros harvest their corn, and I was very impressed that someone from another town would come to help out. And I think that, in a sense, this is, we're trying to support farming in the neighboring communities. I feel that this table 4.6 with number 3, which mentions that you can get a special exception for a sign, would fit these two signs, and I think that that's what we should be trying to grant. I'm not sure we really have to go back to the zoning board. That maybe we could give them the special exception. The zoning board.
We
You
can't based
All right.
upon, yeah.
All right.
So I do want to just reiterate that these regulations are not regulating based upon council's interpretation. These signs are not regulating quote-unquote out-of-town advertisements. It's regulating the signs that are put on residential properties that are producing or selling a certain product from their residents. My concern with denying the signage here in this case becomes a slippery slope, because we have Massaro Farm, we have Savino Vineyards, we have a lot of local nurseries and small businesses that might want a private property, or a private property might reach out to them and say, here, put your sign on, put a sign on my property directing someone to your farm, directing someone to the winery. Based upon these regulations, if we were to agree with council, those signs would not be permitted. And I think that hurts small business.
What would be the problem with having them go back to the zoning board, leave the sign up, let them go back and apply for a special exception? I mean, that's what the regulations
That's an
say
option.
here. And I think it's based on these regulations, we're not opening the town to wide open signage, but we're giving them a good opportunity. I'm sure they would give them that because it's very reasonable. I think that's, I'm just saying, we have a tradition to help each other. I remember that was many years ago, my children were young then, but I was really impressed that he came down from Bethany with a large amount of equipment to help them out. I think it was just neighbor helping a neighbor, basically. And I think we should try to do that, but I think they can get this special exception and it'll fit the tables here. I don't see anything. Meanwhile, perhaps it could be left up until they apply. I don't see any.
I appreciate all you did, I really do. And, I mean, I've been on this board for a while, and I'm still not clear on the regulation as it relates to this, so I so appreciate what you did, because it's clear that it's not clear. And I'm not comfortable, either way, quite honestly, because I think, it doesn't apply to these signs, and I think we have to do the right thing according to what we feel is correct, for this. I don't agree with how the attorney interpreted it either, but
But I do think they have a very strong case to get the signs approved. I mean, it's
I'm sorry, guys, we still.
no, I feel you have a very strong case to get special exceptions. Your property is it's just a few hundred feet from Woodbridge. The roads go, the roads go, the roads that go there are right, and it seems very reasonable, and it would fit with these tables, and I think that I would feel they would give them the exception. I mean, I don't speak for them, but it seems very reasonable, and that would be my recommendation, to ask the zoning board to give them the special exceptions for these two signs.
This is within the board. So I agree with you, Bob, that the way to approach this is, as Celia pointed out, there's a pathway for a special exemption, which goes through the zoning board, not through the zoning board of appeals. And I think that makes much more sense, because it's more generalizable than us making a single decision for a particular sign, as in the Chris Farm, whereas the special exemption would set a precedent within the zoning board and allow others, as we are all saying, in terms of promoting local businesses. So that's my take on it.
I mean, we have to be fair and equitable to Celia's point about other farms, other
Well, that's
the
what I'm
winery.
saying, but
Right.
Precisely, so
But
I think the way to go is to go through zoning, and we've done that before, where you've brought up other issues which we as the zoning board of appeals see frequently, and then alert zoning and say, hey, we're seeing a lot of these. This is something that zoning should be taking care of, as opposed to the zoning board of appeals. So I think that this fits in that category. So I would agree with that, Bob, and say, look, that's the way we should go.
So I think we should let the signs stay there till they apply. It seems.
I don't know that works.
I don't know how that works, but I would feel that would be, if they're going to go ahead and apply, it would seem
Well,
reasonable
I don't
to
know
me.
that we can't do that. So that's up to the zoning enforcement officer, but our recommendation can be to go to the zoning board and seek the special exemption as Celia has identified.
So my concern with that is we are interpreting the language that these regulations apply to the sign. My opinion is they don't do that. And I think planning and zoning needs to edit and change the regulations to specifically preclude these signs. And sending it back to them is creating interpretation that could be harmful to other local businesses.
And the example we had in the other situation, totally different. We accepted the application
Yes. right,
and went
correct.
to
Right.
planning and zoning.
But that was something that had to do with hardship in the land.
Correct.
Whereas this
Correct.
is not a hardship in the land, this is an interpretation of the ordinance. And so.
Which isn't clear.
That's fine, that's why it should go back to zoning.
But I just feel with what's here that I would think they would give them the,
Well,
I mean, I can't
disagree.
speak them, but it seems common sense that they would.
Yeah, but that's
And,
why
yeah.
it's zoning and not
Yeah,
the zoning
yeah,
board of
right,
appeals.
Well, I think the better avenue is to address the language itself and not have them go back and apply.
Well, we can't address that language. The zoning board has to.
Yeah, we would have to propose to the zoning board of
Yeah,
appeals.
yeah.
Or,
Planning and zoning.
Zon-
planning, planning,
I
zoning.
mean,
I don't think that's our function, to tell the zoning board what they should, how they should word something. So this
I
merely
think as a
was-
private citizen,
Well, you can, that's fine.
yeah, I can.
That's fine, but what I'm saying is for the zoning board of appeals, this meeting was to agree or disagree with the zoning enforcement officer's interpretation.
Correct, and there's two ways to go about that. Whether the regulations apply or do not apply, and I think they do not apply.
Yes, okay, well, that's good. All right, so, we'll go back and forth all night.
But it is kind of the same thing in the fact that we did ask planning and zoning to adjust their regulations
Still
on the
can't
other
hear you.
situation.
I'm so sorry, guys.
Sorry.
Well, then, make a motion, we'll go forward.
Mr. Chair, just a point I represent the appellant, and is the appellant going to have an opportunity to address the board?
I think so, I think it's
All right,
proper.
slow down. That is not the function of what we're doing.
I
This
believe
is
that,
not,
Mr. Chair, I just want the record to reflect my objection to your statement. I believe we're here today to discuss and to put on evidence with respect to the actions of the CEO, and we're prepared to do that.
I don't think so.
I'm sorry. Why? Do you have that power as chairman?
Yeah,
He has that power as chairman to prevent any testimony.
And Mr. Chair, I'd just like to state my objection.
Can you
But-
speak for the record who you are and sign in, please?
Yes, thank you.
And then we will address the other issues. Are you acting as a private attorney in this matter or as town counsel for Bethany?
I am a private attorney hired by the Chris family for their farm.
I just want to state for the record that I chair the Inland Wetlands Commission in Bethany, and I have dealings with Attorney Marino as the town counsel for the town of Bethany, and am not sure at all what, if any, issues may arise from that, either in this town or in the town where I reside.
And I'm not expecting any issues. I also am the town attorney in Orange and 8 other municipalities. So, but if you want my resume, I will gladly give it. I'm not here to offend the CEO. I'm here to represent my client and address this issue, which I believe was beautifully captured by you. Thank you very much.
So, can I just, now that you've signed in,
Well, I haven't
at
completed.
the last meeting, when you continued the meeting, you continued it to submit questions that you drafted to council to have a response made. You drafted the questions, they were submitted to council, and they responded. You did not. You had further questions of council, and you submitted further questions. And
That's not the
council
question.
again, and council again responded. Today, you asked me for information regarding how these regulations were written. I was present at those meetings. You were not. And the minutes that you speak of do not capture everything that was said at those meetings. As I stated at the last meeting, there was discussion of the reason that they inserted that, because if you look at the prior set of regulations that were there were no signs that were allowed for non-residential uses. You're conflating this to be far more, whatever you want to call it, than it was originally intended. It was brought forth because there were no signage allowed for churches and synagogues and schools. And every time they wanted to do a sign, they came to the Zoning Board of Appeals. And so they entered into that thing. People who are members of commissions like you and like planning and zoning are lay people, and they do their best to do what they can do. And those regulations were drafted by them. They weren't drafted by council. So I'm just saying, I was there when it said.
We
you-
asked if chairman had the right to allow testimony or prevent it. That was the question,
I
Chris.
thought we closed
And
it.
I was getting at that by saying that at the last meeting, you continued this meeting so that you could hear from council
I
and
don't think-
discuss
I thought we
what you
closed it.
heard from council. And that's what you did at the last meeting.
My understanding is we kept the hearing open. It was not
To
closed.
receive that. But this is your hearing. You do what you wish to do.
So you have not answered the question. Is testimony allowed or not allowed at this
I
hearing?
am not counsel to provide you with that, as well you know.
Chris,
Did we ask?
I am not counsel.
you
I am
provide,
merely stating
you
to
provide
you-
what the rules are at every single meeting.
So,
You know what? I won't do that anymore for you.
Thank you, Chris, for your service.
You're welcome.
Did we close
did we close the public hearing at the last meeting?
I don't believe so.
Look, the only reason it was continued was to do what we were supposed to get, more information, which is what we got. And everyone's entitled to interpret that response from town council any way they'd like to do it. I thought that Dr. Wisnia's response was a good way to go forward. You identified that possibility, which I think is excellent. To me, that's the right way to go forward. I don't really see that there's a lot of for me, there's no further discussion. It's either yay or nay. That lots of discussion isn't going to change the fact that the purpose of this meeting was to get the town council to weigh in. You identified another route, which I think is wonderful. And as Dr. Wisnia said, that to me makes the most sense, and I agree with that.
I do like to state on the record, I requested information from town council, asked for clarification, and was told my comments to town council were ex parte, and I needed to stop asking town council for information.
Okay, I don't know how that doesn't, that's part of our record, which is fine, but
Okay.
It's significant because the purpose of this meeting was to close and ask town council for clarifications.
and we got that.
But if I'm not allowed to do that, he should have been here tonight.
Okay.
I don't think we closed the public hearing at the last one. It would be nice to allow them to.
There's nothing else to say. Only the purpose of this meeting was to get the town attorney to weigh in, period. The public spoke it last time, and we heard it, and I think that was very valuable, and we all discussed it at the time. The only purpose of this was to get further clarification from town council. That has been done. Let's go forward. There is no point, there's not just no point, there is nothing to.
So as a matter of process, I believe it's flawed, because this is an appeal by my client who has since that last hearing hired me as counsel to represent their interests, and the issue is not what the public thinks, but the issue is whether or not the ZEO properly enforced the regulations. And I submit, in the first instance, on May 17th of 2023, when my client received notice, she was not properly put on notice of what regulations she was in violation of. So in the first instance, and I have a lot of respect for you, ZEO, I think as a matter of process, she applies process well. But in this regard, my client was entitled, as a matter of due process, to receive notice of the specific violations that were at issue. That was not included in the May 17th letter of 2023. So as I was sitting here, the importance of that is underscored by your conversation of not knowing what regulations actually might apply. So I think you know, I can't sit here and say that the ZEO was in violation, did not properly enforce the regulations, because I'm not exactly even sure what regulations we're complaining about. So, you know, what I would suggest, I would ask on behalf of my client is, if this matter is kept, my goal right now is to maintain a status quo. Keep those signs up. And I don't think, if you close, once you close and give your decision, unless someone appeals to the Superior Court, you've lost jurisdiction over this matter. I would ask that you refrain from issuing any decisions at this point, so that you maintain jurisdiction, and continue this just another month, so that we then can go back to zoning and we can file proper application with zoning and have a conversation there. Because ultimately, I do agree that there's some amendments that may be necessary to the text, and/or a special exception permit can be sought depending upon that conversation. But I'm not intelligent enough tonight to know which it's going to be until I start the conversation with the zoning commission. So I would simply ask. So for the matter of the additional evidence, I don't think it requires much by way of testimony, because you have the documentary proof in front of you. Her May 17th letter does not have any specificity as to what zoning regulations we're in violation of. And I think that therefore it's a flawed violation, a notice of violation, and that you can find that, and that she was wrong in issuing an NOV without specificity. So, because my
Where
client
is
was entitled to that.
Where are you coming up with this?
The letter does not state what regulation
I
is
understand
violated.
that, but what,
It wasn't, it was a zoning violation. It was the polite first letter that you send. And then you go on from there, okay?
so it was done, correct?
And when
It was
Mrs. Chris called, she said, I will take the signs down, but can I have more time? And I said at that point, you can appeal to the Zoning Board of Appeals. And I said, and furthermore, if you get me that letter on Friday the 26th, I won't be here on the 26th, I'll be here the following Tuesday. And so you didn't hear it until July. And so all I'm trying to say is, I was trying to be as helpful in keeping her signs up as long as I could.
Let's not take this personally, Chris.
Oh, thank you.
Keep it professional, like you told us all at the last meeting.
Okay.
This is not personal to you.
So, do what you wish.
Okay, so I go back to what I said before. I think we should have a motion on,
Wait, he's given
Right.
you,
Has to keep it.
let's get this straight. Your time period to end this hearing, or to make it this, you can end the hearing tonight. You have 35 days. This is why I'm not a lawyer.
Yes, you're correct.
You have 35 days to make a decision. They can give you an additional 65. If I understand you correctly,
Yes, ma'am. You do.
what he's asking you to do is you can close the hearing,
Or not. It's up to
or
you.
not,
Right.
but they will give you an additional time frame in which to
That's-
continue.
Right.
In which case, this is still before you, and her signs, their signs, stay up.
So what the.
So I have
They-
I have
so-
questions.
Can I please finish? Thank you so much. The meeting in September, because whatever discussion you have, whether it's a special exception, requires a public hearing. They will not make a decision. They will schedule a hearing for October. So at a most,
I was gonna call you to have the conversation from a path forward, but by keeping the status quo, it allows us to proceed in a more amicable way, and that's what I'm here trying to accomplish.
Chris,
So we
could you
would
please
grant the
finish?
full-
I want to understand the whole thing that you're saying.
so there's two ways to go about it. You can close the hearing with with all the information that you've got. You can continue the hearing.
So if we
And-
close it, then what happens?
Then you have 35 days to act. And the applicant always has 65 days that they can give you at any time to do a continuation of the hearing, to do a decision, whatever.
Yeah, so
And
my-
I'm sorry if I'm emotional.
No, I understand.
But this last month has been horrendous.
I beg your pardon?
This past month, for me.
I'm only here.
I know, I'm not talking about you, I'm just
Trying to
saying.
keep the peace.
I know, I'm just saying, this past month has not been fun.
This,
Chris, I said to you in the last meeting, don't take any of this personal. You have a very hard job. You do your job
Listen,
very,
I
very
don't
well.
wanna hear it.
And all I was saying is I disagree with you. That is all
And-
I was
and
trying
I
to do here, and you
understand
took
what
it
you're
way
saying.
too personal. You do a fantastic job. You're great at what you do. It's just a difference of minds. It's a difference of opinion.
And that's fine. And I don't live here,
So-
which is part of
And
my
we
life.
understand that, and I'm not holding you personally accountable for
I don't
this.
wanna discuss this anymore, I just wanna get this part done.
Right.
So
So
you
we
have
can either
two choices. You
close the
the
hearing
hearing,
Or,
and you have 35 days to act. They can give you an extension of time in which to act. You can continue the hearing with a maximum of 65 days, at which case you would have to close the hearing, and then you would still have 35 days to act. At that point, I don't think you have any more time.
No, so, right, so if you close the public hearing, it's going to put a finite end to your time period. If you continue the public hearing one more month, so what I suggest is if we continue this public hearing one more month, then I can come back and, in a sense, report this is what we've done. Because again, we don't know scheduling on the zoning commission side, and we also don't know their appetite of what how they're gonna, you may disagree with that, in which case we may wanna prosecute our appeal.
It depends on what you do.
Exactly, so,
Well, here's what I think. I think we should close it.
Please stop cutting him off. I don't think he was finished.
I just wanna create a record, Mr. Chair.
Yes, thank you.
I think I'm entitled to a record.
Yeah,
Thank
yeah.
you. My request is that you keep the public hearing open, you continue it 1 month to a date that is convenient for you, is fine, I'll make myself available. And at that point, I can report back to you as to what we've done and what we'll have a better understanding. By doing that, Mr. Chair, what you're doing is you're allowing your commission more flexibility with schedule. Otherwise, if you close the public hearing tonight, and even if I grant you the full 65 days, which I'm prepared to do, then what you're gonna have is 100 days, right? 65 plus 35 is 100 days. And at the end of that 100 days, there's the magic end where you must render a decision or you've lost jurisdiction. So by keeping this open 1 month, it's giving your commission just a little bit more flexibility.
Flexibility to listen to another discussion?
Mr. Chair, this is a public hearing.
Yeah, I understand, but
And-
what I'm saying is that this is for the zoning board. Listening again to another discussion isn't gonna, this isn't the
Mr.
correct
Chair, I
venue.
represent a dozen municipalities. With respect to this process, this is an appeal filed by my client, who has a burden of putting on evidence before this commission. It's not for the public's opinion, it's for my client to sustain a burden. And I've just given you something that, as a matter of fact, which is in this record, my client received inadequate notice. Now, whether or not this appeal was filed prematurely or not, because we were very early in the process, we are where we are. And I'm simply trying to suggest, not that we want to have a second bite of this apple or renew these arguments. Trust me, I don't. This was one of the few nights off from municipal meetings that I have. And I'm glad to be here representing a good family over an issue that needs to be dealt with, not by you, but by another commission. And I'm just asking for a little flexibility as well, since I've only been retained just about 24 hours ago. And I'm trying to navigate through this without being offensive, but also with respecting my client's rights. So all I'm asking is for a 1 month continuance to allow me to explore what I believe would be the proper way of addressing this. And then if it turns out that the zoning commission is not receptive, then I will know that I have an appeal that I need to prosecute properly. And it's not, Mr. Chair, for the public, again, it's for me to put on evidence that the zoning enforcement officer did not properly enforce your regulations. And that's really what this procedure is. It's not an open dialogue. So I agree with you, Mr. Chair, this should not be open for unfettered discussion. it should be specific if we get there. But my specificity is no greater than, we're not put on proper notice, and therefore our constitutional rights have been violated.
So I have a
So-
question.
So, but I don't think we're gonna have to get there, Mr. Chair, but I'm not gonna know that until I've had the conversation with your zoning commission. And so we will file applications, whatever needs to be filed this week, so that we start that process.
You don't think 100 days will be enough to get there?
I don't know. I don't know what I don't know, and I don't know what, theoretically, yes, but I don't know. It might be 120 days. You know, it depends on the zoning commission. I'm gonna have much more knowledge after I start a conversation tomorrow with Ms. Sullivan and talk about process going forward. And whether or not I should be going with two different parallels, a special exception permit on the one hand and a text amendment on the second hand. Because these regulations can be interpreted a lot of different ways. And I just don't know. And so, to answer your question is, every time a lawyer says it's only gonna take an hour, assume it's gonna take 6. So is it gonna take 100 days? I don't know, it could be 120 days, it could be 102. But I'm just trying to afford this commission the retention of jurisdiction, so that my client signs don't have to, once you've made your decision, and I don't appeal to the Superior Court, those signs can be taken down by your public works, right? If someone wants to enforce what is been, assuming that you find in favor of your CEO. So I don't want to put you in that position. I'm trying to take the heat off of you, Mr. Chair, by you don't have to make a decision with respect to the CEO's actions if it resolves. This matter might be able to be withdrawn.
Thank you for that testimony. I believe if it was precluded, we wouldn't have been presented with that option.
Cindy, you had something else?
What I was going to ask is, it's leaving us an additional 30 days or 1 month. However, there's not going to be any burden to the town as far as, we're not going to ask any more attorney advice. We're not going to spend any money. So there's no money spent to leave this open.
Well,
There's
What
nothing
I'm
that
trying to
we
figure
are
out is
going
what
to be
happens in
doing.
a month from now, in terms of making a decision. What new information, what new data will
It
exist?
allows them to have more time to do what he needs to do, to go to the planning and
Well,
zoning
that's
commission.
that's planning and zoning, but what new information will we have in 30 days? And the answer is nothing.
I don't know that.
What new information are we gonna get?
We're not gonna have any new information from our
But-
town attorney, right?
But if we do that, then they could leave the signs up until the zoning board decides one way or another, is what he's
One-
saying.
When they appeal, it stays in enforcement.
Yeah.
So while this is active,
Yeah.
the signs stay. It's very simple.
So we give them another time, and then we'll see if they're gonna go to the zoning.
So that if we have to make a decision in 30 days, that means we close.
But then he can give us more time, right, at that point, right?
If you close today and I grant you
Sure.
65, the maximum amount of time you have is 100 days.
Yeah.
If you keep this hearing open, we have an undesignated number of days, right? Because we haven't started that decision window yet.
Correct.
The
So if we-
decision window's always 35 days.
But if we
With
close-
all due
if we
I
respect.
can under the statute, 8-7D, I can extend that by 65 days.
If we
as well.
if we close the hearing in a month, what happens then? If we close it in a month? Then you have the 100 days after that? Is
Then the
that-
100 days would begin to, my point of asking for you to keep this open is twofold. One is,
Wait a minute, Jen, just so you know, they've already used their time to continue the hearing, so if they continue the hearing again, it has to be on your dime. Because they started the hearing on July 10th, and so they've continued the hearing until today.
right, when you say you're, my time, what does that mean?
That means they only have 35 days in which to hold a hearing.
Right.
So
we're
they
holding
have
it.
35 days from when they started and on, so it's not really up the 35 days yet, but it's almost there. So from July 10th, 35 days out is when they have to close the hearing,
Unless it's extended.
unless there's an extension given
Right.
to continue the hearing. But And then they also have 35 days in which to act. So the maximum amount of time is whatever extra days there are between July 10th and today that isn't eaten by the 35, plus the 35 that they would normally have to make a decision, plus the 65 that you would have that you could give.
Correct. So-
And that's
Right,
the
that's it.
most.
Right,
And
right.
that's the most.
So what we're looking at is saying, no, let's grant you the extension of, for the sake of this conversation, the full amount of our extension is 65 days. Theoretically, you could keep this hearing open the maximum of 35 from the date that it was first noticed to 100 days. I think, again, math is keeping us
Yeah,
consistent,
whatever it is.
right? And then at that point, you close your public hearing and you have then 35 days to make a decision. It's where you apply
No.
the 65.
No, they only have 35 days from the 10th to whatever that gets us to. And then you could give an extra 65 days,
Correct.
and then once the hearing closed, they would still have 35 days in which to make a decision.
That's right. That's what I was trying to say. If I didn't say it artfully enough, I apologize.
Everybody got
But-
that?
So basically, it's
Basically, 100 days from now.
Plus a few, because
Yeah,
we're
plus a
not
few.
at
Approximately.
quite at
Approximately.
right where we are, because there were
So what
21
happens
days
in 100 days from now?
in
If you
July
don't
and
have-
8,
if
so
you
we're
don't
at
have-
29. We've got 6 extra days floating
Well,
around.
Right, Mr. Chair, the issue is twofold at that point, in my view. One is, it may become moot, right, because of action of the zoning commission. In which case, if it's moot, you can be dismissed for mootness, or we can withdraw it. Or what we can do is, again, for purposes of preservation of a record that is going to be reviewed by a court potentially, I don't know, because I haven't had a chance to really, to listen to last meeting, whether or not my client, was either given the opportunity or did what I believe would be its burden, right? And that is to address what the CEO did. That's really, this is not about selling ice cream, this is about whether or not the CEO acted properly in enforcing the regulations. Now, ultimately, you could decide, well, we understand her position, but we disagree for the following reasons, or you can say, yes, she was right. But I think I should be afforded an opportunity to simply capture what I believe would be at least a specific reason why this order should not be sustained by this body. And that is, the notice issue. That I'm concerned that my client was not given proper notice of what section she violated, and then you would have to render your decision. You're either gonna agree with the CEO or you're not. It's really a matter of business, not a matter of anything to get excited over, right? People lose and win every day. What we're trying here, though, is to find an accommodation that maintains the status quo to allow my client the right to go to the zoning commission and not have to worry about someone taking down her signs, or its signs.
Well, how many days would you have? You have like 6 days plus the 65 you're gonna give
So
us?
hypothetically, if I do this right, you have until the 14th to close this hearing on your own. And then that doesn't get you to your regular meeting in September, for which I'm not here, thankfully. But that's okay.
No litigation for that, Chris.
So then that leaves us with, wait a minute, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 17. We've got 17 days in August, and you would give us a 35-day extension to do something to begin with. So then that would leave us with 18 days, right? 3 plus 15. So that would get you to the 18th of September, which is the third Wednesday in September, which is fine, except that I chair wetlands in Woodbridge, or Bethany, and that's my night to chair, but that's okay. But anyway, you can always have a meeting another night. So you could give them 36 days and get to Tuesday, if you wanted me here, but I don't need to be here.
But again, I would hope that it's simply a report back at that point, and not, because we can't do anything in the CEO's absence, in my view. I don't think that would be fair to her. So,
I don't care.
well, except that again, it's my burden to say why and your burden to say why not, right?
So again, I'll ask, what happens if you don't have anything from zoning by that deadline?
Okay, so let me just, because I wear my other hat of also working for them. They have a meeting on Tuesday, the 5th. And more likely than not, there might be 2 applications, as he suggested, that would get submitted. One would be an application for a special exception, which may or may not be, dependent on how you read the regs,
Right.
what can be done. And because it's a special exception, it requires a hearing, so that would go to hearing the following month at their regular meeting of the 2nd. The other thing that he could do would also be simultaneously to submit something that would perhaps cleanse the language of the text of the zoning regulations. When that gets submitted, because it potentially has an effect on other towns around, it has to go to the Council of Governments, which fortuitously does not meet until the 14th of September. So even if it came in on the 5th, I could send it to them for their meeting on the 14th, and then, because they have to have a certain time frame to be able to respond back, and they would be able to have their opinion back to planning and zoning by the 2nd. At which case, there would be 2 potential hearings being held. One would be for a special exception for the signs. One would be to modify the regulation and do something. They can act on it the night that they have a hearing, unless there's some big conundrum that comes along. If they modify their regs, they can't make it effective that night, because I have to do certain things and whatnot. So hypothetically, they usually give me 2 weeks. So if they adopted something, if that's the route we went, then probably we'd see a text change if it all went wonderfully, somewhere around the 16th or 23rd of October. Failing that, there might be an application that was granted for a special exception to allow the signs on the 2 separate properties wherein they lie, although you have to double check and make sure that the sign that's on the Acorn Hill side is not on the town road right of way, which I suspect that it's on right now, and not on private property. But that's another whole kettle of fish. And that's where we're at.
Okay, that's what I wanted to
And
know.
this is like a big board game.
No, it's fine. So
That's why we
so-
need you here, Chris.
So that makes sense. All right, fine. So,
So at this stage, give them an extension to the 18th, or the 19th. And if you can meet on the 19th, I can be here.
the 19th of,
September, it's a Tuesday. I can't meet on the 18th. I chair another board in another town that I have to be at.
19th.
That town happens to be that town.
Okay, 19th of September.
I'm available.
I'm
Yeah.
available.
Yep, me too.
Okay.
Okay.
So we would cancel your regular meeting for the 11th, since I'm
Yeah,
not here.
okay.
And then anything that came in would be for the 19th.
For the 19th.
Does
Okay.
that work?
Yeah, so it would just be a motion to continue this to the 19th.
And then you can give me,
And I'll
you'll write me a thing and send it to me.
I make a motion to continue this meeting
I second.
The hearing.
to the hearing to September 19th.
19th,
Tuesday, September 19th.
Are we at 7 o'clock?
7 o'clock.
7 o'clock.
Okay, we have a second? Okay, all in favor?
Hi.
Okay, it's unanimous.
Now you can adjourn.
Okay, can we have a
Motion to adjourn.
thank you, Sean, do we have a second?
Second.
Okay, all in favor?
Aye.
Okay, fantastic. Good job.